He is Marshall Chriswell. It's time for another installment of Martial Law. This program intended to be for informational purposes only. The information does not constitute legal advice. The law is constantly changing. The information may not be complete or correct depending on the date and your particular legal problem. Each legal problem depends on its individual facts, and different jurisdictions have different laws and regulations. And because of those differences, you should not act or rely on any information in this segment without seeking the advice of a competent attorney licensed to practice law in your jurisdiction for your particular problem. And there's one of those right across the way. He's Marshall Chriswell. Good morning.
Good morning.
You know, how many years have you been doing this?
How many years have I been doing martial law?
Yeah.
I'd say over 3 years.
3 or 4 years?
Yeah.
Yeah. I don't think in all of this time we've really gotten into this topic. People who come to see you generally don't have a lot of experience working with the law, working with an attorney. And so that initial visit with you has to be very, very important. Let's get inside some of those discussions this morning. Somebody comes to you, here's my legal problem. This is what I got going on. I don't know what I should do next. That's where you take over. You have to sit down with them and discuss what their options are. Tell me a little bit about that initial meeting.
Sure. The initial consultation is a time for me to get an idea of what the legal problem is, and to give a brief understanding to the client of what the law is in that general area, what the prospects are for, if it's litigation, we've got to talk about, is there a remedy here? Is this an actual legal case, or is this just a problem that doesn't have a legal solution? And sometimes those things exist. If it's more of a transactional, or say it's an estate planning consultation, I can give you a general idea of what the law is and how I can help to achieve your goals and solve the problems that that you've presented to me, and then once we get through all of those issues, then it's okay. Do I want to take this on? Do I want to take this project on? Mm-hmm. And does the client want to hire me?
Mm-hmm. And this is just me guessing, but I'm guessing that one of the chief impediments to someone going to an attorney, seeking an attorney's advice, is they say, it's just going to cost me too much money. Do they get into those sorts of conversations right off the bat, do you find?
Yes. Most of the time, the client will raise that. If not, I will raise the issue of fees. You don't want to walk out of that initial consultation without everybody having a clear idea of what's going to happen next and how much it's going to cost. So it's really important. It's sometimes a little bit of a difficult conversation to have, but you definitely want to make sure that the client understands and that everybody's on the same page with, okay, how is this going to be billed? If this is a one-time kind of project where you're preparing an estate plan or it's a real estate closing or something like that, it may be handled on a flat fee basis. I can quote a price for this, or I can quote a range, and it's going to be within this range. So for something like that, it's a little more certain, and you'll have some more certainty with the price. If it's litigation, if this is something that's going to be in court, then it's going to be unpredictable as far as how much time it's going to take for me to complete, to achieve your goals or to conclude the case. And so generally those things are billed on an hourly rate. So you want to have a good understanding of how it's going to be billed and what all the details are in the billing as well.
Okay, put those headphones on. I don't know why I gave them to you today. Maybe I just had a premonition that someone was going to call you and ask you a question. We do have a caller this morning who has a question for Attorney Marshall Chriswell. As soon as you get those plugged in and the headphones on, so you can hear this caller, we'll get it going. Good morning.
Good morning.
Good
morning.
I have a question in regard to child custody.
Sure.
Is there still a law in place where if a child reaches a certain age, they can choose which parent to live with, or is that not going on anymore?
So there's no law that says that a child, reaches a magical age, whether, and they automatically can make those decisions for themselves. It's more flexible than that. The Pennsylvania custody law sets forth 16 different factors that go into every custody case, and a judge has got to make a decision, regarding, which household might the child have a more stable life in, where are they going to get better care, which parents going to better manage any medical problems they have, all sorts of things like that. And one of those factors is the preference of the child, with the caveat that, it's the preference of the child if the child is mature enough to express a preference. So obviously a very young child, the court isn't really going to take their opinion into consideration at all. But as a child grows and matures, and it's different for every child, and that's kind of the point, it's flexible. So a really mature 13-year-old is going to have some say in where they want to be. But a really immature 16-year-old might not. It's really a case-by-case basis.
Okay. So if it comes to that, then what is the process of going through that with that child? If the child is starting to express when they're with their other parent that they would really want to live with them.
Sure. So the parent it either needs to file it, and it depends on whether there's already been an open custody case. But if there hasn't, then the parent that is seeking for the child to come live with them or is seeking the change, it would file a custody complaint in the County Court of Common Pleas. Generally an attorney is going to represent you and assist with that. There are ways to do it without an attorney. If there's already an open custody case, then you'd be filing for a modification of a custody order. But that's where the process starts, is with the filing of a petition in the Court of Common Pleas. And then if it's here in Indiana County, and every county's a little bit different, but here you would be scheduled then, once that's filed, you're scheduled for an initial custody conference where the parties would meet with their attorneys without any judge or mediator or anything, and have an informal conference at the courthouse to see if the issues can be worked out. If not, then the court sends you to mediation, and if you can't work out the issues at mediation, you end up at a custody trial. So it can be a little bit of a long process, anywhere from 3 to 9 months, just depending on how contested the matter is. So if it's you kind of want to get the ball rolling.
Okay, thank you.
You're welcome. I hope it was helpful.
Yes, it was. Thank you.
Sure.
All right. And a reminder, you can call Marshall 479-1160 or 349-WCCS anytime his segment is on. And we'll give you information at the end of the segment today about how you can simply reach out to him directly at his law office. In that case that she was just talking about, the judge's discretion really plays into it, doesn't it? The judge has to make a judgment based upon a lot of different factors. Is the child's preference weighted in any way as compared to the other factors of those 16 factors?
The factors aren't really weighted, but if you have a teenage child, in my experience, if you have a teenage child who is mature and can express reasons, if the decision that they're making, that they're expressing to the court, you have a 16-year-old child that says, "Hey, I want to live with mom," and they can back that up with good reasons, and show the judge that that they've thought it through, and that it's not just on a whim, or because mom says she's going to buy me a car or whatever. Yeah. There are all kinds of situations. But if all other things being equal, if both houses are both mom and dad's house are of equal safety and appropriateness for the child, and there aren't safety issues and things like that, all other things being equal, yeah, if the child can express a well-reasoned preference, that's generally where they're going to go.
The questions she just had, we started this segment talking about the initial consultation when people bring their legal questions to you. That sounds to me like that's the typical kind of presentation someone will make when they come to visit you. Do I have a case? What are the legal ramifications? What are the decisions that need to be made? How does the process start? That's sort of like a case history of what we're talking about.
That's exactly the kind of meeting that you can expect, and that. And those are the kinds of, I can give like that a brief understanding of the of that area of law, how Pennsylvania law applies to that situation, and then what are the procedures? There's one thing, okay, the law might be on your side, but what's the procedure to get to where you want to go? And with custody, like I said, it's this, in Indiana County, you've got the conference, the mediation, and then a trial. So there are tons of details there that I didn't get into that would be for a later time. But that's what you can expect at an initial consultation is, okay, these are just the nuts and bolts.
I would assume then that case or any other case, when someone comes to you for that initial meeting, you're not going to try to project what a judge might decide based upon the factors that have been named here today, even if it got into more detail, because you don't know the mind of the judge.
Well, that's a caveat that you always want to give to a client is, I could be right. We could prepare this case. I could be right on the law. We could have good facts on our side, but the judge can always decide to do something different. And so you can never guarantee an outcome. And that's, another thing that we talk about at the initial consultation is the fact that, I can't predict with any certainty what the outcome of the case is going to be. I can tell you similar cases, what the outcome has been in my experience, and with a particular judge or in a particular court, but I can never give you 100% certainty in a litigated case like child custody or something or other kind of lawsuit, because there are just too many factors, and the biggest one is, at the end of the day, what does the judge decide to do? And I have no control over that. I also can't predict how long something is going to take. You saw I gave a pretty wide range there, 3 to 9 months. That's an average custody case is going to take 3 to 9 months in Indiana County, but are there cases that take longer than that, or are there cases that are resolved more quickly than that? Sure.
I know that in the past you have said as well that when you're coming for that initial consultation, not necessary to bring tons and tons of documentation to make your case, because if you continue to pursue the case, there'll be plenty of time for that.
Yeah, I really, at that initial consultation, it's important to bring if the case has been in court already and there have been things filed and you have copies of documents that were filed in court, let's say in a custody case, a copy of the complaint, any petitions that were filed, the most recent court order, so that I can see, okay, this is what the court says that the custody arrangement should be right now. Those kinds of things are important. But to bring in every piece of correspondence or text message or email that you've had with the other party for the past 10 years and, all those things, that's not really necessary at that initial consultation, because we're just looking more at, okay, what are the big issues right now, and the minutia we can kind of get into later.
Lots of questions folks would have, and not just custody, as we heard right there, but their properties, all kinds of different things that they would need to consult an attorney with. And I think that's the main point is don't try to go into a courtroom by yourself without an experienced attorney.
Absolutely. And, you mentioned that cost is a factor, and it always is. So a lot of folks do decide to take on the court system on their own if they can't find help through legal aid or something like that. And, I see it a lot, and I see a lot of folks that don't get the outcome that they would expect because they don't know how the system works, what the procedures are. You get into a hearing, you don't know how to present evidence, what the objections are that you can make to evidence on the other side, all kinds of things that really, at the end of the day, can sway the case one way or the other. So it's important to consult with an attorney, yeah.
Yes, indeed. And you are one of those.
That's right.
And someone wants to get in touch with you, what do they need to do?
Give me a call at 724-465-5826. Online at www.westernpalawyer.com, or stop into the office in the Atrium Building, downtown Indiana.
Very good, Marshall. Thank you.
Thanks.
It is Indiana in the Morning, presented as always by First Commonwealth Bank here on the Voice of Indiana County. That's WCCS, AM 1160 and 101.1 FM. Now we're continuing to follow that situation on Route 56 as there is a traffic situation there from utility lines down across the highway. Josh will tell us all about that when he visits with us in just a couple of minutes.